Get going. Okay, good afternoon, everyone. Thank you for joining us for today's student loan webinar, Understanding Income-Driven Repayment Plans and Update. This is our first 2025, the first of our webinar series with TISLA, the Institute of Student Loan Advisors. My name is Celina Damian. I am the Student Loan Servicing Ombudsperson at the California DFPI. It is my pleasure to be here today with Betsy Mayotte, who is the president and founder of TISLA, the Institute of Student Loan Advisors. She's been working in the industry for over 20 years and has helped thousands of borrowers with their student loans. To get more information on our future webinars, you can subscribe to our DFPI newsletter. Let me start off with some housekeeping items. Throughout the entire webinar, your video, microphone, and chat feature will be disabled. You can enter questions in the Q&A function, but please hold off on your questions until we cover that topic. And just be mindful that this is a public forum, so don't enter real specific personal questions. The event is being recorded and it will be available on our DFPI YouTube page within the next few days. So as many of you know, many changes are taking place in the federal student loan landscape, a lot of uncertainties, and we are aware, both Betsy and I, we work with borrowers. There's many questions and you're concerned about everything that's going on that we hear on the news. So hopefully today we can provide information. All the information is accurate as of today. And this will hopefully help you manage your loans and then make informed decision about your student loans. So let me start off about the DFPI. We are the California Consumer Protection Agency. We regulate companies of financial products to ensure compliance, and that includes your student loan servicers, both private and federal. We accept and evaluate consumer complaints and take enforcement and legal action when these companies are not in compliance. We enforce student loan related protections here in California, and then we conduct education and outreach such as this one to enhance consumer awareness and protect consumers from fraud and abuse. Next, please. And about TISLA, TISLA is a nonprofit that offers free, expert, unbiased student loan advice and dispute resolution to all customers, and that is the TISLA website. They're freestudentloanadvice.org. Next, please. Today, we will be just briefly going over California protections, give you a sort of a 101 because it is really important that you understand these, understand your loans, your loan types before you make any decisions. So we'll go over some of those briefly, talk about the Save Litigation updates, some options, IDR plan updates, the Department of Education Reduction in Force and PSLF executive order, and then, excuse me, closing and resources. And a disclaimer, this presentation is for educational and informational purposes. We are not financial counselors or attorneys. Next, please.
Before you dive in, Celina, I just want to give a big thank you to the Rose Foundation, who provided us with the grant to allow us to do this series of webinars this year as well as last year. We would not be able to offer this if it wasn't for their support. So a really big thank you to that foundation.
Yeah, of course. Next, please. So how much student loan debt do we have in California? We have 4 million borrowers that owe $141 billion of student loan debt. The majority of debt is held by borrowers between the ages of 35 to 49. And we do know that student loan debt disproportionately impacts women, students of color, even elder borrowers. The average debt load of a California borrower is $37,000. And the 3-year student default rate was below 5% for students at nonprofit and around 15% for students at for-profit colleges before the pandemic. In the US, borrowers owe $1.78 trillion of student loan debt, according to the student aid loan portfolio. Next, please. In California, borrowers do have protections under AB 376, which is the California Student Bill of Rights. And I think now more than ever, it's important to stress these protections and for borrowers to know that these are available to them. We are the agency that enforces the Bill of Rights. And what this bill does is it prohibits student loan servicers from engaging in abusive, unfair, or deceptive practices and requires that they work in the best financial interest of borrowers. Servicers must provide borrowers with information and applications for IDR plans and other forms for federal benefits and protections. This includes any PSLF forms, TPD forms, any other forms for any type of discharges. It establishes special protections for military borrowers, those working in public service, older borrowers, and those with disabilities, and they have to provide specialized training to customer service representatives that work with those group of borrowers. It protects borrowers from any negative consequences stemming from a sale, assignment, transfer system conversion. It's really important right now. Even within the past few years, we've had a lot of loan transfers, platform changes. Your account information, your history should remain. You shouldn't incur any negative consequences as a result of any of these changes. In California, a borrower has a right to take legal action against their servicer if they fail to comply with any of these laws. This is known as a private right of action. So a borrower can take individual action against a student loan servicer under this bill. And a borrower can file a complaint with the DFPI or contact me if you are not sure. We want to hear from borrowers. We want borrowers to, I know you're able to file complaints with Department of Education, with the CFPB, but here in California, we also want to hear what borrowers are experiencing, and we want to be able to help them resolve these issues. So whether you need your account history, you have questions about how payments have been applied, anything, what's going on, you want to know what plan you're on to confirm your recertification date, I am strongly encouraging to file a complaint because they should be providing you with accurate information. And this is the only way that a state, we're going to be able to take any action to protect borrowers. Next, please. In addition to the Student Borrower Bill of Rights, you also have your Private Student Loan Collections Reform Act, and this is regarding private loans. So a private education lender, private education loan collector cannot initiate loan action unless they possess certain documents. So it's about 18 things. So if you are, or 18 items that they have to provide. So the court cannot enter a judgment in favor of the lender without providing or introducing these documents. Very important if you are at that point in your where you're getting sued, or you receive randomly just get papers from a company saying that you need to, they're filing this action, they have to provide, you have rights. So very important for those borrowers. And then under the Bill of Rights, we are now including income shared agreements. There are different types of higher education financing. So typically you associate student loans with just your federal and your private loans, but we are seeing new products that they're called income shared agreements, retail installment contracts. So we are now going to be enforcing and regulating those. Those are for more trade schools, or where you sign an agreement with these companies saying that you will pay back a portion, you will pay back these loans if you make a certain amount. So we are seeing a lot of these in the industry. And then your federal protections are all listed here under the Higher Education Act. Those are on your master promissory note. And then you also have consumer protections as a borrower under the Truth in Lending Act and the Fair Credit and Reporting Act. Next, please. I mentioned servicer just briefly. For federal loans, the difference between your lender and your servicer. Your lender is going to be the Department of Education for federal loans, and then your student loan servicer, it's your main point of contact, Advantage, Mohila, Nelnet, Ed Financial, if you have loans in good standing. And these are your servicers. They collect and process your loan payment, process all your changes in repayment plans. And you may be transferred, as some of you know, you may be transferred to several servicers throughout the life of the loan. And if you have more than one loan, you may have more than one servicer. So just understand you are going to have your studentaid.gov, your main portal, and then you will have a portal with one of these companies. It's very important, especially with all the fraud I'll be talking about later. You want to make sure that you have updated addresses with these companies, that you are monitoring all the communication that you're getting there. through any, your messages in these portals. And then if you don't know who your servicer is, you can log on to your main studentaid.gov account and you will see links there directly to the servicers. Next, please. So before we get started, you need to know your loan type. It's very important when borrowers reach out to us, one of the first things, probably the first thing, what type of loan do you have? Very important to know whether you have a federal or a private loan. If your loan is on studentaid.gov, then you most certainly have a federal loan. You may have one of the older pre-2010 loans. You may have a FFEL loan, but you will see that on studentaid.gov. If you do not see your loan on that portal, then you have a private loan. You most likely have a private loan. Another way to check is your credit report. For federal loans, you will see the direct loans, direct plus loans, any loan that was dispersed after 2010. I mentioned the Federal Family Education Loan. Those are the FFEL loans. Those are commercial loans that are backed by Department of Education. They're not fully federal direct loans, but they can be consolidated and into direct loans. Then you have your Perkins loans and then the Parent Plus loans, which will be in the name of the parent. So those are your direct Parent Plus loans. Again, studentaid.gov or your servicer's website to see your loan type. You also want to know when the oldest loan was made or the disbursement date. If you have consolidated your loan, you may see a more recent disbursement date, but the consolidation doesn't change the oldest loan date. So you will see it's called the underlying loan. That's what you need to be looking at, the disbursement date of the underlying loan that was consolidated. Next, please. And then understanding your repayment plans. You're going to have two buckets of repayment plans. You have your non-IDR plans, where the monthly payment is based on your loan balance. Those do not have a forgiveness component. The payment can change if interest rates change or due to periods of non-payment. All federal loans are potentially eligible for all plans. They do have minimum payments. They don't require renewal or recertification. And these generally, excuse me, do not count for PSLF. And the reason we say generally is because the standard plan for non-consolidated loans do count towards public service loan forgiveness. However, because under the standard plan, as you'll see right now, the term is 10 years. Essentially, your loan will be paid off in the same term as the public service loan forgiveness program. And then you have your IDR plans, which are where your monthly payments are based on your family income and size. For these plans have a forgiveness component where after 20 or 25 years, your balance can be forgiven. The payments usually don't change if the balance changes. Not all loans are eligible for all plans, but typically everyone is eligible for one of the plans. There are no payment minimums. They do require annual renewal or recertification, and these count towards public service loan forgiveness. Next, please. And so as you can see the buckets here, I said income-based and non-income based. So I put the standard plan here on its own just because it is the default for all new borrowers. And so when you go into repayment, you will automatically be placed on this plan. You do have to apply for one of the other plans if you want to get out of the other plan. But if you do nothing and you just start repaying, you're going to have a fixed payment for 10 years. And this is the fastest and least expensive plan based on the interest paid. And then you're going to have your graduated repayment plan, which is a 10-year term. The first the 4 years, you're going to have interest-only payments, and then you have your extended and graduated extended. These are where the term extends to 25 years. Extended repayment, these also you have to have a $30,000 balance. And the only difference between these two is with the graduated extended repayment, you also have the 2 to 4 year interest-only payments. And then you have your income-based bucket. You have your new and old income-based repayment plan, the pay-as-you-earn plan, and the income contingent repayment plan. Next, please. Your old IBR, that's going to be all FFEL and direct loans, regardless of the disbursement date. Parent Plus loans are not eligible for this unless they are double consolidated, which Betsy will talk about down the few slides. Then you have your new IBR, which is only for borrowers with direct loans where none were made prior to July 1st, 2014. So after July 1st, 2014, you're eligible for this plan. Again, Parent Plus loans are not eligible for this one. Pay only for direct loan borrowers with no loans prior to October 2007. Again, Parent Plus loans are not eligible unless they double consolidate. And then you have your income contingent repayment only for direct loan borrowers, and a Parent Plus borrower or those loans can access if they consolidate into a direct consolidation loan. Next, please. For all IDRs, they base the monthly payments on your income, and Betsy will explain that. It requires annual recertification. It forgives any remaining balance after a certain period. Forgiven balances will be taxed as income under all IDRs after 2025 unless it's extended by Congress. And then forgiveness is currently at risk for all except for IBR due to the litigation. So that is currently the safest plan. And I've seen IBR just this week. I had a borrower who received IBR forgiveness. They will include spousal income if the taxes are filed married, and then spouses included in the family size. Again, even if taxes are filed separately, it will include the spousal loans if both are enrolled in an IDR plan. They subsidize unbilled interest for 3 years for subsidized loans. You can have a $0 payment, which still considers your status in repayment. So make sure you understand that. Sometimes borrowers think they have a $0 payment and they think they're on forbearance or deferment, and they're not able to tell if they are accruing progress towards forgiveness, PSLF, or IDR forgiveness. So just because you are on a $0 payment does not mean that you are not still accruing interest. And then IDR plans are PSLF eligible payments if you are employed with the qualifying PSLF employer as well. Next, please. And now I'm handing it over to Betsy.
Thanks, Celina. Okay, so let's talk some more about the income-driven plans and how they work. So the thing about these plans that can make them kind of confusing, if you haven't seen it already, is they're all exactly the same except where they're different. And it doesn't help that two of them have the exact same name. We have new IBR and we have old IBR, but those two plans have very different terms. As far as which plan you should pick, when Celina was talking about the non-IDR plans and talking about the 10-year standard, I really like that she said that the 10-year standard tends to be the cheapest plan. Now, notice she didn't say that was the case for everybody, because it's not. The name of the game is to pay the least amount out of your pocket over time. And for some people, that means pursuing a loan forgiveness program, whether that be public service loan forgiveness or the forgiveness that's baked in to these income-driven plans. But for other people, it might mean paying their loans off aggressively to reduce the total interest paid over time. And for other people, the strategy might change halfway through. Maybe you start off pursuing a forgiveness program and then something changes. Maybe you're not working for a PSLF eligible employer anymore, or maybe your income jumps way up. And you end up switching gears and start paying your loans off aggressively. I say all this to say, you should never set it and forget it. I'd really love to start a new trend here in the United States, very similar to the whole thing where we're in the habit of checking the batteries on our smoke detectors and carbon monoxide detectors at daylight savings time, or at least I hope you are. I'd like to start a thing where everybody reevaluates their student loan strategy at tax time. The reason I say tax time is because when you're doing your taxes, you already have almost everything you need in front of you to do a good reevaluation of your student loan strategy. So anyway, keeping all those things in mind, let me sort of go back on script a little bit and explain a little bit more about how the income-driven plans work. So as Celina mentioned, they all base your payment on what's called discretionary income. Now, listen, when we say discretionary income in day-to-day conversation, we mean something that's very different from how discretionary income is defined under the income-driven plans. At least I know when I usually talk about discretionary income, I mean the money that I've got left over after I've paid all my bills and hopefully put some money into savings and to retirement. For want of a better word, my fun money. But discretionary income for the income-driven plans is defined as your adjusted gross income minus a certain percentage of the poverty level based on your family size and state. And the percentage of the poverty level that they use depends on which payment plan you're on. So for new IBR, old IBR, and pay as you earn, they're subtracting 150% of the poverty line based on your family size. For income contingent repayment, they're only subtracting the actual poverty line itself, so 100% of the poverty line. For SAVE, now you notice I don't really talk about SAVE here, and that's because SAVE is dead. We just don't know if the courts or Congress is actually going to be the one to bury the body, so to speak. SAVE used 225% of the poverty level, and it's one of the reasons that for most people, for that brief, sweet period where people were actually making payments on SAVE, that payment plan tended to be lower than the other plans for many borrowers. So the way the calculations work is they take that discretionary income and then they divide it by 12 and then multiply it by whatever the percentage is required under the particular income-driven plan you're on. So as an example, let's say we have a borrower who has an adjusted gross income of $62,000. They have a family size of 4 and they're living in Maryland. 150% of the poverty level for a family size of 4 in Maryland. And by the way, I think this is based on last year's poverty level numbers, not 2025. But 150% of it would be 26,200. So you subtract that, from the 62,000, that gives us 22,700. We divide that by 12, that gives us $1,892. If this borrower was doing either new IBR or pay as you earn, we'd multiply that figure, which again is our discretionary income, by 10%, and that borrower's payment would be $189 a month. If they were on old IBR, we'd multiply it by 15%, and that borrower would have a payment of $283 a month. Now, just as a reminder, and Celina did mention it, but it's worth repeating, if you're married and you file your taxes jointly, they're going to use both incomes in the calculation. There's just no way around that. I shouldn't say there's no way around that, but the only exception are extreme situations where the borrower can truthfully say that they don't have access to the income information, which if you file jointly, you have access to the income information. That exception is really only for cases of domestic abuse. Now, if you're married and you file your taxes jointly, not only are they going to use both incomes, but if both spouses have student loans and both are on an income-driven plan, they'll actually use both loan balances in the calculation between the two of you. So oftentimes, if both spouses have loans, and I say oftentimes because nothing's absolute, the cheapest payment for the household between the two of you is going to be if you file your taxes jointly, so you can get those sweet, sweet tax credits. But they also, again, take both loans into account if you're both on an income-driven plan. Now, if you file your taxes separately, they're only going to use your income. The exception being community property states, where if you file separately, your income is 50% of the total income between the two of you. Now, something that has recently changed, and that's due to the SAVE litigation, is part of the regulatory package that the SAVE plan was put in said that if you file your taxes separately, you can't use your spouse and your family size. And the reason that's important is the bigger your family size, the bigger poverty level number they're using to subtract from your original adjusted gross income. So we want our family size to be as large as possible if our goal is to make the payment as low as possible. But because the entire regulatory package is currently under injunction, we're back to the old reg, which means that even if you file your taxes separately, you can now count your spouse and the family size, which means they're going to use a higher poverty level. Now, whether that sticks around depends on how this SAVE litigation shakes out. And I'm going to talk more about that in a little bit. Now, the other thing you have to keep in mind as far as eligibility for these income-driven plans, For all of them except for ICR, you also need to show that you have what's called a partial financial hardship. Now, a partial financial hardship exists if your calculated payment under the income-driven plan is less than what you would have paid under a 10-year standard plan. So if we use the example on the prior slide, where the borrowers, the income was $62,000, family size of 4, under new IBR and pay as you earn, which is the 10% calculation, their payment would be $189 a month. Let's assume they had a principal balance of $60,000. Now, their payment under a 10-year plan on a $60,000 balance would be somewhere around the $700 mark. Now, $700 is clearly a lot more than $189. In fact, it's even a lot more than the $280 some odd dollar amount that would have been their payment under the old IBR plan. So in either case, this borrower has what's called a partial financial hardship, and assuming that their loans meet the other criteria, meaning they are either direct loans or in the case of old IBR FEL, and they don't have loans older than either 2007 or 2014, depending on the plan, then this borrower would be eligible for those income-driven repayment plans. One thing about the partial financial hardship, a couple more things actually about the partial financial hardship. There is no PFH requirement for ICR. So technically everybody's eligible for ICR unless they're a non-consolidated Parent Plus loan. The other thing is for the plans that do require a partial financial hardship, which again are old IBR, new IBR, and pay as you earn, there is a cap to the payment. So if your income increases over time, you continue to recertify your income as required. If you get to the point where your calculated payment under those plans is the equivalent to the 10-year standard amount or more, they'll just cap your payment at that 10-year equivalent. You're still on new IBR, old IBR as pay as you earn, meaning those payments still count towards things like PSLF or the income-driven plan forgiveness, but your payment will never go any higher than that 10-year standard. For ICR, which doesn't require a PFH, there's no limit to how high your well, I shouldn't say there's no limit to how high your payment can go. The way ICR works, there is technically a limit, but it can be technically be the threshold isn't the same as what it is for those other plans. All right. So before I talk about the double consolidation loophole for Parent Plus loans, I'm going to take a breath and check in with our Q&A people and see if there's any questions about anything we've covered so far that we think should be covered with the whole group.
No, not yet, Betsy. I think people are just taking a minute to digest, and the questions will start pouring in a minute.
Okay. Yeah, there's a lot. All right. So Celina mentioned along the way that for Parent Plus loans are eligible for all the non-IDR related plans, full stop. They don't have to jump through any hoops. They don't have to cross their fingers or make a wish or anything like that. It's the income-driven plans where it gets more complicated. So Parent Plus loans in and of themselves are not eligible for any of the income-driven plans. If Parent Plus borrowers consolidate their loans just a single time, they then become eligible for income contingent repayment, but only income contingent repayment as far as the income-driven plans go. When you consolidate, you remain eligible for the non-income-driven plans. But there's something we used to call it the super secret double consolidated loophole, but it's not a secret anymore. So now we just call it the double consolidation loophole. Now, by loophole, let me be clear. It doesn't mean it's illegal. It's absolutely legal. It's now written into regulations, as a matter of fact. But the way the double consolidation loophole works is essentially what you need to do is you need to consolidate each of the Parent Plus loans twice. And once you've consolidated each of the Parent Plus loans twice, they now become eligible for the other income-driven plans, including IBR, new IBR, pay as you earn. And that's assuming the borrower meets the other eligibility criteria, such as no loans prior to 07 or 14, depending on the plan. Now, what I mean by consolidating twice, I'm going to give you an example, but before your head starts to spin too fast, If you go to the TISLA website, which is freestudentloanadvice.org, and go to our consolidation page and scroll down to the bottom, we have step-by-step instructions on the double consolidation loophole. But just to give you an example, let's say you had 4 Parent Plus loans, and we'll call them loans A, B, C, and D. First, you'd consolidate loans A and B together and create consolidation 1. Then you'd consolidate loans C and D together, creating consolidation 2. Now each of your Parent Plus loans have been consolidated once. The last step is you consolidate consolidations 1 and 2 together to create consolidation 3. And now you've double consolidated your Parent Plus loans. Now, they did put a deadline on the double consolidation loophole of July 1st, meaning you had to be done. You had to have created consolidation 3 by July 1st to qualify. But, and this is sort of one happy thing, I suppose, about the SAVE litigation, that deadline was part of the SAVE regulatory package. And because that whole regulatory package is currently under injunction, that means that deadline doesn't exist right now. Does it mean the deadline's not coming back? No, it could absolutely come back. But for those of you that are just learning about the double consolidation loophole and going, jeepers, I don't have time to get this done. You might still have time to get it done. I wouldn't dawdle. I'd start today. But worst case scenario, you start the process, you don't complete it by July 1st, and the deadline of July 1st comes back. You're still eligible for ICR. You're still eligible for those other plans, the non-income driven plans. So you really don't have anything to lose by attempting this. The only people I would suggest maybe doing a little bit more research before diving in is somebody with a Parent Plus loan that maybe some of their Parent Plus loans already are really close to forgiveness under PSLF, and they have newer Plus loans that aren't. You might want to email TISLA to talk that through before you jump into that. But for everybody else, you really don't have anything to lose by at least attempting to start the process. And again, I don't see the actual July 1st deadline coming back. It's not impossible, but I think the chances of that are fairly slim. But again, even if it does and you don't make it, you really haven't lost anything. All right, so let's compare the plans. So if we look at someone who has a balance of $95,000, they have adjusted gross income of 30 grand, they have a family size of 2. And if we assume an income growth of about 2.5% a year, under a fixed payment plan, under a consolidation loan of 30 years, the borrower would have a payment of about $570 a month, and they'd pay back a total of a little over $200,000 by the time they were done in principal and interest. If they were on old IBR, their payment would start out at only $52 a month. It would, again, with those income growth assumptions, their payment would never get above a little over $100 a month. After 25 years, they will have only paid back about $23,000, and then the rest would be forgiven. Whether or not there would be a tax implication would depend on whether the forgiveness happened before the end of the year and or whether Congress extends or makes permanent the tax moratorium on the forgiveness component of the income-driven plans. And by the way, if you're within the sound of my voice, you might want to consider reaching out to your member of Congress and encouraging them to extend that tax moratorium. For new IBR, so remember, old IBR, they use 15% of discretionary income. New IBR, they only use 10%. So for new IBR, the numbers go even lower. Your monthly payment starts off at $35 a month. Assuming those income assumptions, it doesn't ever get higher than $64 a month. And after 20 years, they would get the borrower would get forgiveness and will have already paid, would have only paid back $11,500. Pay as you earn is the fraternal twin of new IBR. So the numbers are the same. The only difference between pay as you earn and new IBR is when you took your loans out. Remember, for new IBR, you can never have had a loan prior to 2014. For pay as you earn, you had to have had no loans prior to 2007 to qualify for those plans. Now, I put in revised pay as you earn here, which is the old repay, which the old repay doesn't exist. The reason I stuck this in there is because back in January, so as I mentioned, we know SAVE is dead. We just don't know sort of what the autopsy looks like there. But back in January, the Department of Education issued a Federal Register where it appeared like they were trying to rewrite Repay to fit with what we're seeing so far as what is giving the courts heartburn over the SAVE plan. The other thing that's happened more recently is the Department of Education has announced a process called negotiated rulemaking, where they're looking to make some changes. We don't know what those are yet, to pay as you earn and ICR. So I put in numbers based on the draft language that came out in January of what a new plan might look like. I can't underline or bold the word might enough. We don't know if this is going to happen. But based on that language, we ran some numbers for what that might look like for a borrower if that plan were to go forward. And it would be fairly similar to what we saw for new IDR and pay as you earn. If there was a forgiveness component, it would be after 25 years, the borrower would pay back a total of $15,700. And for ICR, this borrower's payment would be a lot higher. They'd pay $213 a month. It could go up as high as $400 based on our income assumptions, but they'd pay back a lot less than what they'd pay back on the standard 30-year plan for consolidation. Now, none of these take PSLF into account. If the borrower is pursuing public service loan forgiveness, the time frame would be a lot shorter. The total paid back would also be a lot shorter. All right, so before I get into the SAVE litigation, I'm going to check in again real quick with Addison to see if there are any questions about the plans themselves that we need to cover.
As expected, lots of questions about SAVE.
Oh, poor SAVE. All right, so as I mentioned, it's a foregone conclusion that SAVE is not coming back. We just don't know if Congress is going to kill it as part of budget reconciliation or whether the courts will do it. And if the courts do it, whether the courts do it or whether Congress does it, we don't know what that looks like for the borrowers already on SAVE. I am as certain as I possibly can be, which only means 95% certain, that SAVE borrowers won't be grandfathered into SAVE. Any payments they made prior to the litigation would still count towards income-driven plan forgiveness, or it would count towards PSLF. But they wouldn't be able to make future payments based on the SAVE plan. Now, what happens to those borrowers remains to be seen. My expectation is that they might be given a period of time to choose another plan. And if they don't choose another plan within that period of time, they'll automatically be put on whatever the next lowest income-driven plan is. That's pure prognostication on my part. No one's whispered in my ear anywhere. There's nothing in writing anywhere. It just, to me, what makes the most sense of what they might do there. And we also don't have a sense for timing. If Congress does it as part of budget reconciliation, I know that they're trying to get that budget reconciliation done by July. I don't have a timeline for the courts as far as finishing that out. Now, when SAVE goes away, we also don't know what happens with the rest of that regulatory package. And that's important for things like the double consolidation loophole deadline of July 1st. Does that come back or not? The family size definition for pay as you earn, does that come back or not? Other things affected by that regulatory package is, it allowed certain deferments, such as economic hardship deferment or cancer treatment deferment, to count towards income-driven plan forgiveness. It created a buyback possibility for income-driven plans. So we don't know if any of that stuff is going to come back. If the courts just say, never mind, if Congress is the one that gets rid of SAVE, in which case the rest of the regulatory package would stand, or if the courts end up saying the whole regulatory package is gone forever. The other sort of sticky wicket here is, even though it wasn't part of the original lawsuit, and nor is it part of the SAVE regulatory package, The courts are questioning whether the forgiveness component, specifically for income contingent repayment and pay as you earn, is lawful, which is like bonkers to me, is because ICR has existed since 1994, and no one's ever questioned the forgiveness component to that. So right now, right this second, because of the injunction, there is no forgiveness for ICR and pay as you earn specifically. The reason pay as you earn is there is because pay as you earn is not under statute. It was written under the income contingent repayment plan umbrella. IBR, both of them, both new and old IBR, have their own legislation, and the word forgiveness is actually part of that code, which is why the forgiveness component for old and new IBR are not at risk. Only the forgiveness component of ICR and pay as you earn. And just to be super clear, I'm not talking about PSLF at all. Those plans, all of them, still count towards PSLF. PSLF forgiveness is not at risk under any of this. So again, depending on what happens with Congress and the courts, we don't know what happens with the forgiveness component for ICR and pay as you earn. And if they do end up saying that the forgiveness component is unlawful, we don't know if they grandfather in for forgiveness those borrowers that have been on ICR and pay as you earn, or if they don't. What we do know is that, remember, all the income-driven plans cross-pollinate for each other towards forgiveness. So if you're on ICR or you're on pay as you earn and you're real close to forgiveness, or maybe you're already at that threshold, you should see if you're eligible to switch to either new IBR or old IBR. And really the only reason you wouldn't be able to switch is if you didn't meet the partial financial hardship requirement for those plans. They are processing forgiveness for IBR. Celina mentioned it earlier. I've seen people get forgiveness under old and new IBR as well. What am I forgetting about the SAVE litigation? Oh, so because of the SAVE litigation, so there's been two injunctions. There was one last year, and then there was another one on February 18th. The February 18th injunction is the one that closed off everything in that whole regulatory package, not just the SAVE plan itself. And it's because of that they had to pause new income-driven plan applications. And those are still paused. The application's once again available. If you've looked at it and compared it to the old one, you'll notice they got rid of the SAVE plan from that application. They also changed some language, such as around family size. I mentioned how family size changes for borrowers who are married and file their taxes separately because of that regulatory package. They also, for people that were due to recertify their income-driven plans, which remember, in normal times, which we haven't had normal student loan times since 2020, but in normal times, you're supposed to recertify your income on an annual basis, and that's coming back. And for borrowers that were due to recertify their income prior to this other injunction, you still had to do it. But for people that were due to recertify since the second injunction, your recertification date has been pushed out. And if it hasn't been pushed out, it will be. Now, just to clarify those recertification dates. So it can get confusing because you've got two dates if you're on an income-driven plan. You have your so-called anniversary date. So let's say the first time, your first payment that was ever due, the first time you got on an income-driven plan was March 1st. That's your anniversary date. That's it. That's when things are going to change for you if you fail to recertify when you're required to recertify. That's also when things are going to change for you if you do recertify and your payment changes because your income has changed. And then we also have your recertification date. Now, you're due to submit your recertification information at least 45 days before your actual anniversary date, because it takes the servicers a minute to actually process that information. And if you fail to submit by your actual recertification date, then it's possible that your payment could jump up to what it would be under the 10-year standard amount. You don't, for IBR, new IBR, pay as you earn, and ICR, if you fail to recertify on time, you don't actually get kicked out of the plan, but they do put you on the 10-year standard. So for those borrowers who had an anniversary date on or before March 17th, and they were due to recertify their income on or before February 20th, you submitted on time and the servicer processed it, you've got a new payment, nothing's going to change for you. If you submitted on time, but the servicer didn't process it, your due date for recertification is going to be extended and they're not going to process your recertification at all. If you didn't submit on time, your payment probably shot up. And you need to recertify as soon as possible. And you're going to be due that higher payment amount until they're able to process it. If you can't afford that new payment amount, you can call and ask for forbearance. Now, if your anniversary date was on or after 3/18, and or you had a recertification due on or after February 21st, then they've extended your recertification. If you already submitted it, they're not going to process it. And if your payment increased, they will eventually revert it back to what it was before they increased it. Now, all this information can be found on the Department of Ed's website, which is studentaid.gov, under the Save Litigation. There's a whole bunch of Q&As that you might want to take a look at. All right, so the last things I was going to mention today were about the recent reduction in force the Department of Education has had and what that means and what that affects and what it doesn't affect. And we get a lot of questions, and we know there's a lot of anxiety around the executive order that was issued a few weeks ago around public service loan forgiveness. So I wanted to talk about that too, but I want to check in for more questions again with Addison before I do that about the income-driven plans.
Yeah, a couple of good questions. One on, will extended recertification dates get moved back if the administration so decides? So if someone was moved to 2026, could they be moved back to 2025?
I mean, it's not impossible, but there's a way less than 1% chance, in my opinion, of that happening. It would just open a whole bunch of cans of worms because borrowers have already been notified of the extended recertification date. So I just don't, I can't see a good reason for them to do that.
And also a couple questions about, are they still doing the auto recertification with tax information, or have they paused that?
My understanding is that they have paused that, and I don't think they've brought it back. Now, we get a lot of questions from borrowers on the SAVE forbearance. A couple I want to cover. This, the SAVE forbearance is supposed to be a zero interest forbearance, and there are some servicers that are handling it that way right now, but there are other servicers that interest is still accruing. And my understanding is that for those, the interest will be reversed once, at a later date, probably once the SAVE forbearance is over. We saw this with the COVID forbearance too. So if you are on the SAVE forbearance and you're accruing interest, I wouldn't call your servicer about it. I would just, they will, I mean, it's in writing with the Department of Education. And we saw something similar with the COVID forbearance. Another really FAQ that we get is, I'm on the SAVE forbearance. What do I do? Should I switch plans or should I ride it out? There's no one answer for that. There's so many variables as to whether borrowers should plan on writing out the SAVE forbearance or plan on switching plans right now. Some of it depends on if you're pursuing loan forgiveness. For borrowers pursuing PSLF, you will have the opportunity to do buyback to get those SAVE months to count, but we don't know what the calculation is going to be. If they're going to use the SAVE calculation, you'll probably save money by writing out the SAVE forbearance and planning on doing buyback. But if they end up using the next lowest income driven plan, it could be a wash, or it could end up possibly, costing you more money. So, and then unfortunately, we just don't know the answer. This is all uncharted waters. Nothing like this has ever happened before. Some borrowers are writing out the SAVE forbearance and banking the extra money and earning interest on it on their own, and they plan on making a lump sum payment later. If you're pursuing loan forgiveness under the income-driven plans, there is no IDR buyback right now. And I don't know if there will be. Frankly, if you forced me to gamble on that, I'd say there probably won't be an IDR buyback. So you might want to consider switching. But there's like a dozen other variables there. So there's just really no one straight answer for that. All right, let's talk about the reduction in force. As I think everybody's aware, the administration laid off approximately half of the Department of Education staff, which was really troubling. I know a lot of those people, a lot of them have been working there for many years and have a really strong knowledge base. And it's a shame that we've lost those people. What I can tell you is that the terms and conditions, and this also applies if the loan should, which is a big if the loan should move to another agency, like the executive order suggesting they move over to the Small Business Administration, the terms and conditions of your loans are written into your promissory note, federal law, and federal regulation. The fact that we've lost a bunch of Department of Ed staff and that the loans may be moving to another agency doesn't change any of those loans, terms, and conditions. The other thing is that a lot of the student loan functionality is actually done by vendors, such as the loan servicers. So your day-to-day communications, answering the phones, billing you, processing deferments, processing income-driven plans, those are all processing PSLF. It's all done by vendors and servicers. So none of that has changed either. What we did lose is we lost a lot of the people that were laid off were part of oversight teams. So the entire teams that did oversight for the servicers, 80% of the people that did oversight and did audits and program reviews for colleges and universities were laid off. They laid off a bunch of IT people. They laid off most, if not all, I know there's at least one person there, if not more, of the ombudsman team. So we lost a lot of the helpers, which is incredibly unfortunate. But as far as the terms and conditions of your loans and the day-to-day processing of your loans, none of that has changed. I also want to briefly mention the executive order that was issued a couple of weeks ago that would prohibit borrowers who work for nonprofits where the nonprofit engages in quote unquote illegal activities. I know terrorism was mentioned as one of the list of potential illegal activities. Wouldn't be able to use that service towards PSLF. Now, that is part of that. What the executive order said was it instructed the Department of Education and the Department of Treasury to do what's called negotiated rulemaking to change regulations to put that executive order into place. So what that means is nothing's happening immediately. The other thing is executive orders can't violate federal law. And I'm not an attorney, but the law around 501c3 status for PSLF doesn't have a lot of wiggle room. So I'm not sure that the Department of Education can create a regulation that disallows service under a 501c3. I do think it's possible that they make some changes to nonprofits that aren't 501c3s. And I suppose I'm not as familiar with the statute around the definition of a 501c3 under Treasury law. And so because of that, I suppose it's possible that current 501c3s that engage in these so-called illegal activities could be made not 501c3s anymore under Treasury. But again, nothing's going to be immediate. The negotiated rulemaking process takes at least a year, and they can't make changes to regulations retroactively. So nobody who has accrued service under any of these employers that you think might be at risk under this executive order have to worry about losing that prior service. And there's a big question about whether this executive order would even pass the legal authority. If the Department of Education were to pass a regulation that was in conflict of federal statute, someone would file a lawsuit, and it would likely be deemed unlawful. It's not dissimilar to what we're seeing with the SAVE litigation. The Department of Education passed those regulations. The 13 attorneys general thought that they exceeded their authority there. It went to court, and it appears that SAVE is going away. So this would be a very similar process. We already talked about that. I already talked about negotiated rulemaking. Celina, did you want to talk about scams?
Of course I do. Thank you for all that information. Thank you for the great questions. I think out of everything Betsy said, really, there's not a one size fits all. There is a lot of we don't know yet, but the best advice is really to stay up to date, and then keep in contact with your reliable resources. We are seeing a lot of scammers taking advantage of this time of borrowers' confusion. You may be receiving a text, an email, even something in the mail from a company that is offering to help you with your student loans. They are offering forgiveness. They are offering to consolidate even when you don't even need consolidation. So it is very important that the borrower knows who their servicer is, who they should be dealing with. They know if they filed a complaint, was it with the DFPI? Was it with the CFPB? Who did I file my complaint with? That way you know who to expect a response from. You should not be paying anyone for any type of, well, this is for those that are in high school, parents possibly, but do not pay to attend any scholarships or financial aid seminars because we are seeing fraud in that area as well. Verify the information and research the company. Now with the internet, it's easy to just Google the company and you will see if they have a website. At the bottom of the page, they will say, we are not affiliated with the Department of Education. If you see typically an 800 number, you get the same email from like just a personal name, a personal email address, and it has an 800 number. Be very careful. These companies have names like that sound very official, but they are not official. Do not give out your login information, your FSA ID number. Do not subscribe to any monthly service or sign a contract. We are seeing borrowers that sign power of attorneys, and it makes it very hard for them to recover the money. They have to go through the bank. It's a whole issue. Just remember, there's nothing that a company can do for you that you can't do on your own for free. You can contact myself, Betsy, your student loan servicer. That's what they're there for. If you're receiving multiple calls a day offering special access, something's guaranteed, and this is with anything, not just with your student loan, it may be a scam. Please give us a call, file a complaint with the DFPI or the FTC, even the CFPB if you are have been a victim. Next, please. I believe this is our resources page. Next. Yeah, so here are some links to studentaid.gov, some links from TISLA, and then my email as well. We also have a student loan empowerment network for borrowers in California where they can receive counseling further, more than one session if they have issues with their private loans, even legal aid assistance for borrowers that qualify. So this is a network that's available for borrowers, but you can always shoot myself or Betsy an email if you have more questions. Is there anything else? We have 3 minutes left. Anything? And thank you, Betsy. Anything that we just want to touch on? Just the last message before we go?
I loved your messaging about the scams, Celina, and I just want to reemphasize, here at TISLA, we never ask for, in fact, please don't ever send us your personal information. We don't want your SSN. We don't want your login. Once in a while, if we're helping you with a dispute and I have to reach out to the Department of Ed or your servicer on your behalf, I'll ask for full name and date of birth just so they can find your account. But we'll never ask for that. And nobody legit is ever going to ask you for that either. And as Celina said, there's nobody that can get you forgiveness faster, or more forgiveness than you could do yourself for free. And even if you're not a victim of a scam, if you see something that's scammy, please report it to the Federal Trade Commission, or the CFPB. The FTC in particular has been doing a great job going after these student loan scammers.
Yeah, and other states also, just keep in mind too, other states have Bud's office, they have Attorney General's office who are all aware of what's going on. They monitor. So if you're in another state, know people that are in another state, borrowers, please feel free to share this information and have them reach out to their Bud's office, their AG's office, and to get information as well, or file a complaint.
Yeah. Celina and I are really lucky. We both live in states whose attorneys generals really understand student loans and the issues around it, and for years have fought very hard for consumers. So coast to coast, Massachusetts and California. The last thing I want to mention is for people that are checking out TISLA for the first time, you may want to check us out again in another month or so. We are doing a huge refresh of our website. So, but don't worry if you came here looking for Alice the student loan cat. Unfortunately, she decided to take a cat nap. But all the TISLA pets will remain on the TISLA staff page as well as the human staff. I want to take a minute. Well, let me just check in one last time with Addison to see if there's any other questions we should cover. And then I'm going to do all my thank yous and set you all free.
Nope, we're good.
Okay. Well,
And before that, I'm sorry, can I just mention our next, before you, our next webinar is April 29th, and it is our Parent Plus Loan webinar. So again, it's on our DFPI webinar outreach page, but it's on April 29th.
thank you for that. And actually, anybody within the sound of our voice, please tell everybody about these. Even, ask your employer to send the link out to all the employees. We got this really generous grant from the Rose Foundation, and I would love to be able to go back to them and tell them all, like, lots and lots of people that we were able to help. This is free, will always be free. So thanks again to the Rose Foundation for that. Thank you to Addison and Katie for working the Q&A. They're awesome. And of course, thank you for Celina, my partner in student loan information, for these webinars. I love working with you.
Thank you. And thank you, everyone. Have a great rest of your week, and we'll see you soon. Bye-bye.
Bye-bye.